You may have seen the first two videos where I'm interviewing the appellate lawyer Kyle Singhal from the law firm of Hopwood and Singhal out of Washington, D.C. The first episode, we learned a little bit about his background. The second episode, we really focused on the appellate process. And here in the third and final episode, we're going to be talking about post-conviction remedies, particularly commutations, executive clemency, that kind of thing. So stay tuned. Thank you. When I was in prison, a lot of times people would look for any type of vehicle that would allow them to give the jurisdiction back to a judge so that they could hear it, because otherwise they're just not in the game, and they were trying anything they could. But today, you mentioned the First Step Act, and today there are a little bit more opportunities maybe to access the court, particularly in light of this Section 3582 with compassionate release. Could you give us a little bit of insight on how that motion works and why that motion might be of interest to people in prison today?
Absolutely. That's something that we've had great success with, especially recently. And it's a fabulous provision that allows judges to really take a second look at sentences that might have been too harsh. As long as the judge finds extraordinary and compelling circumstances that warrant a sentence reduction, the judge can reduce the sentence. I will say the term compassionate release gives the impression that it's always going to result in release. That's not necessarily true. It's a provision that allows for a sentence reduction. It has been used with great success to result in the release of folks who have already served a good deal of time, but at least theoretically a judge could use it to cut, say, a 20-year sentence into 10 or something like that. I think the important point is there are administrative remedies that someone who wishes to pursue relief under the First Step Act must follow. And there's ongoing litigation now about how precise one has to be. But essentially, if someone wants to pursue compassionate release or a sentence reduction in their sentencing court, they first have to file the administrative remedy with the Bureau of Prisons. And if 30 days from filing their request goes by with no response, they can then go to court and file a motion for sentence reduction there. But if the warden denies the request, etc., they have to include a copy of that with their motion in court. So if you go straight to court first, then the court will likely say that you have failed to exhaust your administrative remedies, and that's just going to cause ongoing delay.
So in today's environment where we have this pandemic going on around the country and judges have been intervening in some jurisdictions, at least that's my understanding, does a person, even during the COVID era, that if they want to bring it to the court, do they also have to go through administrative remedy, or do they not?
Absolutely. Yeah. No, the statute, the great development in the statute was allowing the prisoner to go to court, but only after they go through the administrative remedy. And so it's essentially a 30-day waiting period. If you get no response or an unfavorable response after 30 days from the Bureau of Prisons, then you go to court at that point.
I think it's always difficult to get a different outcome. Your team has been really successful in helping people get different outcomes through various channels, whether it's through habeas petitions or appellate petitions, or as you said now, in light of the First Step Act with these new remedies. But people who have lost at every stage in the proceedings that have very long sentences, there's another option that is called executive clemency. Could you help our audience understand a little bit more about what are the different types of executive clemency?
Right. So the two primary options are commutation of a sentence or a pardon. Commutation of a sentence typically involves lowering a sentence it can be from death to life, or it can be from a term of years to a lower term of years, which can result in release if the term of years that it's lowered to is time served. And then the other option is a full pardon, which of course would also entail release, but also would include full restoration of rights, such as the right to own firearms and whatnot. There are a few different avenues, I suppose. Now, this is going to be dependent on the administration. So if someone is watching this and there's a different administration in office than there is today in September 2020, everything could change. But under the current administration, there are sort of three avenues of executive clemency. One is the standard. You go through the office of the pardon attorney, who would then make recommendations that that are acted on. That's not being used much of it all right now. Two is the president has an advisory board that gathers and makes recommendations, and that has been used and acted upon. And then three is the president himself has full power, unfettered authority to grant pardons or commutations for any reason, but only for federal inmates, we should say. And then all of this executive clemency that I've been referring to applies strictly to federal crimes. If someone is in the state system, they would have to go through their state, presumably governor's office or board of pardons and paroles to pursue clemency there.
So it's always the chief executive officer of the jurisdiction.
Sure. That's right.
Yeah, that allows it. So in federal, it would be the president. In the state of California, it would be the governor. And in some places, it's my understanding that they actually have pardon boards, board of pardon and paroles, which is almost like a parole board that can review and assess. If a person is going into the system and wants to be thinking about that, what steps might he take to make your job easier when it comes to hire the firm of Hopwood and Singhal to say, I'm interested in executive clemency, whether it's a commutation or a pardon, and I'd love for you guys to represent me. How could that person become a great client for you?
I think the most important thing is to present all the facts and really have factual documentation on paper that shows candor right up front, because what's difficult is if you hire a lawyer, whoever it is, and you only tell them part of the story, and then sometime down the road the rest of the story comes out, and it's just better for everyone to have whatever the full story is, to have that up front. And so whether it's all records from police reports, there's obviously stuff that can be obtained from public dockets like indictments, but the police reports, other law enforcement records that maybe the defendant has access to that aren't as easily available to us or to whoever the lawyers are, having all of that, victim statements, just everything that could be relevant up front, and that will enable the lawyers to take a look at how to present the case candidly and accurately. It's not typically to the prisoner's advantage to continue fighting guilt at that point, but rather simply to have the facts up front, put them on the table, and then decide based on that what the best avenue for relief is.
So that's kind of a mechanical, formulaic strategy. What about the more, rather than focusing on that static, because he can't change the fact that he did some crimes, are there mitigation steps that might really make a case more likely to advance with the process, or make it easier for a law firm to argue more persuasively on why an act of mercy is worthy in this case?
Well, certainly behavior during confinement is crucial. I mean, excellent behavior and taking as many steps as possible to show rehabilitation, to show education and helping others, and getting recommendations. So it was a first step case, but recently we had a case where someone's 213-year sentence was reduced to 20, and having recommendations of wardens, I think, was crucial to that outcome. So anything someone can do, I think you make a great point, that's dynamic as opposed to the static factors of their conviction, to show that they, sort of an odd phrase, but deserve mercy. But to show that I think what you'd like to do is persuade someone in a decision-making position that if they release the prisoner, that the prisoner's not going to get out and do some bad act that then they'll regret the pardon or whatever it is, right? And I think we've heard the president say things like that, like, all right, go and do good things now that you have your liberty. I think there is a general fear among those who give pardons or clemency that what if I give a pardon to someone who then goes out and commits some heinous act, right?
So as somebody who did 26 years in prison and I'm communicating to people in jail and prison, I asked that question because I want you as a viewer of the Prison Professors Program to be thinking about that today. You know, it's not easy to do. It's something that I had to be thinking about at the start of a journey, is saying, how do I want to emerge from this? And I know it's difficult when you're living in prison or you're in jail and you've got influences around you that are telling you how to adjust to confinement. But if you want a different outcome, if you want a lawyer to take your case and argue in the most effective way to get you the relief that you want, you've got to do your work to try and make it easier through your mitigation of it. Avoid disciplinary infractions, pursue an education, build a record that shows that you are worthy of people believing in you, build a strong support system. All of those are factors that led to relief for guys like Adam Clausen, who they represented and got that sentence down. And you'll hear Adam's story on this program. But I want you to be thinking about yourself. Yesterday, I got a call from a guy in prison that's serving a life sentence, and he's been in jail for 30 years. But the key is he's trying now to reform his life. It's not an overnight challenge to overcome things of that sort. It's a matter of sowing seeds early, nurturing it, and over a period of time, building that support. And I really want to thank you, Kyle, for spending time with us and helping us understand the ways that you help people, and certainly getting a reduction of a 200+ year sentence down to 20 years is a phenomenal outcome. It's something that really is a community effort where the inmate has to help and you have to help. And then you have to, of course, have the right judge or chief executive that's going to give you that relief. But I'd like to ask you one final question, if I could, about Second Amendment matters. You'd mentioned that earlier in your thing, and I have a personal relationship with a fellow who got his Second Amendment rights despite having a felony. Is there any insight that you can provide us with how somebody might go about getting Second Amendment rights if they have, say, a white collar crime?
That's honestly not my area of expertise, Michael, so we may wish to cut that also if you want.
Yeah, that's fine. Okay.
Give me a different final question if you want to reverse.
Let me try another final question then. Well, no, I'll just close out with. So again, Kyle, I just want to thank you very much for sharing your story or sharing your area of expertise with our audience. And I really want to recommend Kyle. I know him personally. I've met him personally. I've also seen the great outcome that he and his team have gotten for another friend of mine, and not only Adam Clausen, who was serving time in prison, but an individual who has just faced a prosecution. So I will personally vouch for him, and I hope that you will, if you're looking for appellate counsel or habeas counsel, you will consider the firm of Hopwood Singhal in Washington, D.C. I'm going to leave the last words with you, Kyle, and say, is there anything that you might want to express to our audience? And our audience are people who are either going into the prison system or people who are in prison.
Well, I'll say two things, Michael. First, your story is inspiring, and it's just great to be here and be a part of your programming. So thanks again for having me. And for those who are watching, just never lose hope. No matter, you don't know what the future holds. You don't know what changes could come in the law. And if Adam Clausen had a 213-year sentence and didn't lose the hope that he could help people and lead a meaningful life every day, then keep the hope. There's good you can do with opportunities that come every single day, and don't let them go to waste.
So in the show notes below, we will have, of course, links to the Hopwood Singhal law firm. I will provide information that what I've learned from them. So if you have not, if you're watching this in the community and you have access to YouTube, I do hope that you will subscribe to the channel. And if you have needs of an appellate attorney, if you're facing a sentencing hearing, it might make sense for you to send an email to speak with Kyle and see if there's some service that he can provide for you. Thank you.
All right. Thanks, Michael. Take care.